All right. Welcome to another episode of One-on-One. Today's going to be a fun one. Kathy, it's good to see you again. And
Hey.
we are joined by one of our friends and colleagues, Alex Mihai, our general counsel. Alex, welcome.
Hi, thank you.
This is I'm going to address the elephant in the room. This is going to be, we're talking law today. And so I have my notes and Kathy does as well. And we're going to really let Alex let you guys in on some pretty vital information. So I kind of just want to get going. Can we just kind of start, like, maybe list off some hot topics that are happening right now in the industry from a legal standpoint?
Sure. So there's several of them that I guess affect the industry as a whole, not local issues, but you have cybercrime issues that are always a hot topic. You have the typical ADA accessibility for websites. Agents have sites, making sure everyone can access those sites. That has come up. You have RESPA issues that involve settlement service, procedures and how brokers interact there. You have a very significant lawsuit taking place today that involves NAR and several of the bigger brokerages. They're being sued for alleged antitrust violations, which could really impact agent commissions, among other things, and how we basically do real estate, depending on the result of that case. And then you have some other issues, just fraud type claims that you see. You see the typical non-disclosure cases that we get in our lawsuits involving our transactions, broker transactions. So that's
That's a lot.
Yeah.
That's a lot. Here's what I'd love to do, because Alex, for most realtors like myself, it can be overwhelming. I mean, just that list you gave us was overwhelming and makes, that little fairy on my back go, oh my gosh, we need to worry about things we didn't even know we needed to worry about. So it's always good to have good counselors like you. It's good to be well represented. Can we just today, and Josh, probably what we need to do is schedule multiple times with Alex and pick apart a lot of these. What I would love to talk about today, Alex, with your permission, and your expertise, is that antitrust. Because what gets my attention is when you say things like how realtors get paid. Yeah. That makes me pause.
I completely agree. I want to apologize really quick because we need to take two steps back. And Kathy and I obviously have a very, very good relationship, and we know Alex very well. But for those that don't, maybe give us a quick 15 to 30 seconds.
Sure.
Yeah.
Your background and your expertise, obviously.
Sure. So I joined the company in 2015. This is my first official podcast. I did one with Mark about 2 years ago. I joined the company in 2015. We had about 6,700 agents then. So I feel like I've sort of had this front row seat to see the explosive growth of not just our agent count, but our office count, marketing team, just everything that we've done. It's been very exciting. I'm a licensed attorney and a licensed broker here in the state of California. I was in private practice at a private law firm here in Orange County, California, for about 8 years before I joined Realty ONE Group. I specialized there in litigation, and I worked with cities and police departments defending civil rights type claims. It's much different than what I do today. But real estate has always been sort of a passion. That's why I got my broker's license. And when I spoke to Kuba about joining the company, it was a wonderful opportunity to again have that front row seat and seeing his vision, sort of take part right in front of my own eyes is pretty cool.
Yeah, no, I think we've all witnessed it from our own point of view, and it's pretty spectacular to be along for the ride. We're obviously very, very, very fortunate to have you on the team. But yeah, let's jump back into it. Let's talk this antitrust case. Yeah,
I think first it's important to get a working definition of what antitrust is before we just talk about the antitrust case. If I was listening and I was a broker, an agent, or someone else, I'd want to know what does that mean exactly. So we have laws in the United States. Some of them most of them are passed by Congress, federal laws. The antitrust laws was a bill enacted by Congress years ago, and it basically says that companies can't get into cahoots and fix prices to at the detriment of a consumer. So you can't have Toyota call Ford and say, hey, sell your full-size truck at $40,000 and I'll sell mine at $40,000, and we won't give these guys another choice. So these anti-competitive practices are not allowed in our country. So that's what we mean when we say antitrust. You can't price fix. It's one of the elements of antitrust violations. So what's being alleged in this case? This case was filed about 3 years ago. It's out of Missouri. You have plaintiffs who are basically home sellers that are alleging that there's price fixing going on in our industry. And so these plaintiffs sold their homes, and they're curious to know basically why they're having to pay the commission of the buyer's agent. So if I'm selling my house, they don't feel they should pay this commission that's already set in most cases, mostly in all cases, whether it's 3% or 2% that goes to the buy side. Why am I having to pay that when I don't have any relationship with the buyer's agent? I don't know what services they're going to render for the buyer. None of my business, but you're making me pay this, and people are doing it all across the board. So is this price fixing? Mm-hmm. So named in that lawsuit is NAR, Berkshire Hathaway, Remax, Keller Williams, and Realogy. Basically the top.
All the big hitters.
All the big hitters, right? So they're all named. And then, Realogy obviously has all their brands that are named. So again, the allegation is that there's these inflated commissions that are consistent all across real estate, and they shouldn't have to be paid by sellers. And that's the crux of this lawsuit. One interesting thing about this lawsuit is that the Department of Justice sort of caught wind of it. There was complaints made to them, so the Department of Justice got involved. And when they get involved, they're basically investigating sort of these antitrust issues there. So it's one thing to say it in a civil complaint where you're asking for money damages. It's another thing for the Department of Justice to get involved and say, do we have like a national issue here where there's price fixing among brokers?
So where does NAR stand on this? Like, where's their position?
Yeah, no, that's a great question. So NAR's position is essentially that the system, the real estate system we have in the United States, which is really based on cooperation between brokers through a shared marketplace. We call them MLSs. Mm-hmm. These multiple listing services allow any agent from any brokerage to list properties for sale and advertise them for sale. So NAR is going to say, look, this is the most competitive environment we can provide, because if you're a small broker with 2 agents, if you're a large broker with 100,000 agents, you still use the same service.
Right.
If you're a first-time buyer, if you're an investor that's bought thousands of homes, you still have the same information available to you. So if you try to suggest that the environment all these brokers work in is anti-competitive, that's just not true, because it gives everyone an equal playing field to view homes. It's probably the most accurate information you can get when it comes to property searches. You can go on Realtor.com or Zillow or some of these other places, but the MLS itself, Kathy, you probably know just as much about MLS as I do. That's where you're going to get your most accurate information. That's where brokers type in the info themselves with their own fingers, and it's not replicated by another third-party company. So,
exactly. And, I wonder, I'm just sitting here wondering, because I've been in real estate a long time, Alex, and I remember when it was the good old boy network. I'm from the South, and I'm sure there are pockets all over the country where it was the good old boy network, and they probably all did get in a room and say, hey, this is what we're going to charge. But I think that was before MLS. I think that was before the internet. That was before it became such a competitive arena. So, if the antitrust had been filed 30 or 40 years ago, I might go, hey, yeah, there might have been some of that backslapping. This is what we're going to charge. But I'm like you, in this environment, I just can't imagine.
Yeah. So where does the case stand now?
So the case recently, the court, it's venued again in Missouri. The court granted what's called class certification. So you'll see likely some advertisements happening by the plaintiff side. They're going to say, hey, we're filing this class action. Mm-hmm. If you sold the home between these dates, I believe it's between sometime in 2015 to present. If you sold a home in this area of Missouri during this time, you're part of this class. And you'll get these little flyers probably in the mail. Those folks in that area will. And if you want to opt out, you can. If not, you're part of the class automatically. So class certification doesn't mean that there's any finding of fault. It's a procedural legal course that takes place in a lawsuit. The judge doesn't look at the merits of a case to decide if he's going to grant class certification. They take a look at the potential plaintiff's class to determine if all those plaintiffs have something in common, which is they all sold their homes. So there's got to be commonality. The facts arise from the same, issue, so to speak, which is home sales. So yeah, class certification was granted. That's kind of where it stands. The decisions on the merits have not sort of been adjudicated yet. A couple interesting things, Josh and Kathy, on this one is, so we sort of talk about the competitive environment, but when it comes to commissions, the argument is that, hey, they're all the same. Everybody from, Missouri to California to other markets, they're all at 6%, let's say, or thereabouts, right? So how is that possible? Mm-hmm. How is it possible? These guys all must be in cahoots. Well, I know for a fact that, our CEO, Kuba, doesn't call the CEO of Remax and say, hey, you should list all your stuff at 6 and all this my stuff at 6. That's not happening. I know that. So it's going to be very hard for these people to prove this sort of conspiracy element that we're all in on some fix. It's the argument NAR is going to make, going back to your question, Josh, what's NAR's position is that we set commission based on what the market bears. There'll be some markets now where it's 4%. There'll be some markets where it's 5%, but it's what you can even charge 8% commission if you feel like you should. It's what the market bears. I see it personally as no different than the, let's just call it the food industry that sells pizzas. You can basically go out and buy a medium pizza for $10. So if you're going to Domino's or Pizza Hut or Papa John's, they're all going to have like a $10 sort of pizza. Are they all calling each other and say, let's sell your medium for $10, I'll sell mine? No, they're probably not doing that, but that's what the market bears. Right. That's what the market's going to pay. So that's where we're at. The one sort of point that is made by plaintiffs in this case, which I think is interesting and I think will change, and it's one of the things that the Department of Justice investigated, is advertising services is free on the buy side. Mm-hmm. So you and I were talking about this when we were off camera. Yeah, go ahead. Yeah, it's interesting. So inside the complaint, they cite to Keller Williams training manual, and at Keller, they, according to the complaint, they train their agents on the buy side to say to their clients, hey, you don't have to pay me anything. To you, it's going to be free, and they use the word free. Mm-hmm. And NAR had some language in their guidelines to their agents, that are part of NAR, that they can advertise their services as free, because on the buy side, the buyer is not paying a commission of any sort, especially not to his agent. That was one of the issues that was highly contested in the complaint that's going to be litigated here. Is it really free when the buyer's agent is in fact making money? Mm-hmm. They are earning a commission. So whether it's 2% or 3% or however it's identified on the listing, there is money going to the buyer's agent. But the question then becomes is, does the buyer's agent's client, the actual buyer, does saying that his it's free to him limit him from then wanting to negotiate any of the potential commission going to his agent? Got it. So if I'm a buyer and I think my agent's done a horrible job representing me, or I think he's done a great job representing me, he's going to get the same amount no matter what, according to the way we practice real estate. So that's one of those interesting issues where should buyers be allowed to sort of negotiate with their agent on how much they get paid based on the service they're getting? Most industries, you tip somebody serving you. You base the tip sometimes on quality of service. Good service, you get this much. Bad service, you get that much. Right. You can't really do that in real estate based on the way we practice real estate. So that's one of the issues that I think may change. It is one of the points that was, so when the Department of Justice investigated this, they ended up reaching what's called a settlement with NAR. And there's some disputes on that settlement. But one of the points in the settlement that NAR gave into, and this is public information, is that NAR said, okay, we will get rid of advertising services as free. We will no longer do that as an industry. So we will get rid of the word free. We will not say it's okay at NAR. We will tell our brokers that belong to NAR, you can't advertise your services as free on the buy side anymore, which opens the door to buyers potentially negotiating that commission. Right. Okay. The other thing that's on the table in that settlement is the offer of compensation being made to the buyer. That's got to be disclosed to the buyer. Sometimes it's not. If the buyer just gets if the buyer's receiving a listing from his agent that says, hey, let's go see these homes, here's a listing, that listing doesn't always say what the offer of compensation is to the buyer's agent. It just may not be in there.
That's an MLS regulation.
That's an MLS regulation.
That should be addressed at the MLS level, because most MLS is like, if it's a 6% commission, if it's a 3.3, or if it's 5%, it's 2.5, that is disclosed in MLS. That does not mean the buyer sees it.
Yeah, does not mean the buyer sees it. So now it's got to be disclosed to the buyer.
Okay.
It's interesting what you just said there, Kathy, because in the Las Vegas market, this was true at the time this complaint was filed about three and a half years ago, 2019, end of 2019, I believe. One of the things an agent can do in the Las Vegas MLS there, where we have obviously offices as well, an agent can send his client homes to view, and there's all these toggle features. You want to see 4 bedrooms and 2 baths. You want to see 3 bedrooms and this and that. This neighborhood. We can limit all these features and just send them listings in that area. One of the toggle features on their MLS there was toggling by the commission that the buyer's agent would receive.
Oh, that's interesting.
So as an agent, if I'm your agent, Josh, and you're my buyer, I can send you, if I wanted to, all homes for sale that were being offered at 3% commission for me. So I wouldn't send you the ones that are 2% or 1% because I could potentially make less commission. So if you wanted to see all 3-bedroom, 2-bath homes in, let's say, Henderson, Nevada, I can put one of the toggles as at 3% commission. So it'd be 3 bedrooms, 2-bath at 3%. There could be some other ones at 2%, but you might not see those.
So it's advantageous for the agent.
It's advantageous for the agent. So they got rid of that really quick there. But that's one of the things that these plaintiffs are going to sort of harp on to sort of change things. That's one of the other. When I say the settlement between NAR and the DOJ, one of them, like I mentioned, Kathy, we talked about the disclosing of the commission to the buyer that the buyer's agent will get, not advertising the service is free, and the MLS is not being allowed to have these filtered base commission amounts where the clients would only see so many. So that's another one on there. And then the last point that I understand between NAR and the DOJ that they're negotiating on is having lockbox access made available to all licensed professionals. So there got to be
explain that a little bit.
Yeah. There are times, I guess, where depending on the MLS system, some of the boxes are electronic, some of them are mechanical. I don't know. There's all these different ways of doing it. Mm-hmm. Some of the agents have access to them. Some of the agents don't have access to them. Some agents could be limited by the MLS for whatever reason. One of the things that the DOJ wants is that any agent have access. Anybody that's licensed has to have access so their client can get in. You can't sort of exclude one client or another client because of the agent not having the proper tools or mechanics. You got to be able to let them in somehow. So if they're not signed up for the electronic sort of lockbox, somebody has to go there and open the door for them. So they have to be able to allow their client to get in. There can't be this exclusion because the agent's not equipped and not paying his, $35 fee a month or whatever it is.
I understand that. I totally disagree with that because a lot of times, like those the advantage, and I just want to be the devil's advocate and speak to the other side of that. A lot of times those electronic lock boxes are safety and security issues. Mm-hmm. And in my opinion, I want to know that a realtor is paying dues and they're members of the MLS. And and one of the benefits of being members of the MLS is access to lockbox combos. Yeah. And I think that, Alex, becomes a big discussion because to me it becomes security and credentials and a lot of other things that, I agree with leveling the playing field, but as long as it's not detrimental to potentially to the consumer. And when I think you're casting your shadow, not you, but I think DOJ is casting their shadow in an area they don't need to be in. Just my opinion.
Okay. No, that's understood. There certainly could be some safety, security type issues. I don't think the electronic boxes are going to go away. I just think if an agent doesn't have access to that electronic system, he is now able to call who he needs to call to get that door open. So if the listing agent needs to show up and open the door for him, that needs to happen now. I think that's kind of where they're going with it.
Okay.
So those are the 4 big things that are part of this settlement that's on the table. The DOJ is sort of backed out of the settlement. NAR has filed some motions to push them to get back to the settlement table. We want to obviously resolve as an industry. We want to resolve any issues we have with the Department of Justice. That's not somewhere you want to be hanging out with.
I know you've pretty much answered this question, but just to kind of like wrap it all together, should members of NAR be concerned about this case, or what do you think should be the reaction from this?
Yeah, that's a great question. I think they should keep an eye on it, to the extent that they're, Inman publishes news on this case. Yeah. I think they should also be, from a good practitioner standpoint, I would want to make sure that I have agreements with my buyers that I am representing them. A lot of times, and you might see this too, Kathy, we have buyer agents that don't really sign anything formal with their buyer clients. They're just kind of waiting for the point in time where their buyer is going to say, yep, I want that house. And then they prepare an offer together, and then that's sort of their paperwork. But there should be a formal agreement that you have as a buyer's agent with your buyer that says, these are the services I'm going to offer you. This is some of the work I'm going to do for you. So it makes it very clear that I'm working for you. I'm doing things for you.
Yeah.
It's funny, Alex. I love that you're saying that. And one point I want to make, because there will probably be people like me that go, what? What do you mean? Because I'm in North Carolina. North Carolina, we've had that agency disclosure, mandate agency disclosure. That is a big offense with the North Carolina Real Estate Commission if you don't disclose at first greeting representation for buyers. If I didn't have the opportunity to work nationally like I do, I wouldn't realize how many states don't have that. So on behalf of our viewers, I think it's important to know this is an issue that you may be, like me in North Carolina, in a state that has full disclosure mandate, really high standards for disclosure of agency representation, or you may be in a state that has none. So I just want for the listeners to be able to go, okay, wow, I didn't realize there were states that still didn't do that, where we are so heavily mandated. So that's a very interesting point that, to me, that's an our issue, that maybe that should be standard, should be one of the standards.
Yeah. I mean, we really only scratched the surface on this one, haven't we?
Yeah. There's still a long ways to go, and how our commissions will be affected, what we can and can't say as agents about the commission, what rights potentially, sellers may have to just pay their own agent as opposed to the other agent that's cooperating with them. That can all kind of change. It may. I don't see it. I definitely see changes in terms of not advertising your services free. I think that's going to go away because there is compensation being made. I think there is going to be some more disclosure between the buyer and the buyer's agent, around what type of commission the buyer's agent is getting. So those are all things that I think happen today. Those conversations happen today between buyers and their clients. Yeah. And obviously it is not a good practice to send your client only listings at 3%. Just don't do that. Just send them what they're looking for. Don't toggle by the feature that allows you to just send them the high commission paying homes. But yeah, this case is going to be ongoing. We're going to continue to watch it as a broker. I'm going to continue to get information out to the leadership here at our company, so they can then get it out to our brokers and franchise owners. We'll follow it. Because we've gone international, we've expanded our company internationally, and I've got to have a sort of a sense of how real estate is practiced in other countries. Yeah. And this is by far the best way. This is the best way, the way we do it here. Yeah. I'm not saying it's the best, but it's better than all the rest. Yeah. Like Winston Churchill said, democracy is not the best government, it's the worst government, but it's better than all the rest. Right. So it's kind of like that. You do have a centralized system where all the listings are exposed, and there's requirements, Kathy, depending on the MLS, you got to get them up there in 24 hours. 24
hours, yeah. You have standards around that too.
Yeah. You can't just...
No more pocket listings.
No more pocket listings, but that's the way the rest of the world basically runs, off pocket listings. You're a broker in Spain or South America or wherever it is, you get someone that comes in your office and says, I want to sell my apartment, my flat. Okay, I'm going to put it up on the wall. I got a couple people I can call. Yeah. We'll see if we can get it sold. I
know a guy.
I know a guy who's looking. I know a guy who's looking.
It could always be worse. Right. Well, I mean, like Kathy said, I really want to do it like a legal series. I think that'd be fun. So we're going to definitely have Alex back for a few more episodes. But we really, really, really appreciate your time and all this information. And yeah, we'll definitely have you back on soon. Yep. So thank you very much.
All right. My pleasure, guys. Thanks for having me.
Thanks, Kathy.
Thanks a bunch.
Thanks.
We thank you for joining us today on another episode of One on One, a Realty ONE Group podcast. We are powered by One.U and ask if you have suggestions, recommendations, or questions, please email learning@realtyonegroup.com. And remember, pay close attention to the details. Listen to understand, not respond, and always be a resource, not a sales pitch.